This is the California Regulatory Explainer on regular versus emergency rulemaking. California's Office of Administrative Law, or OAL, is charged with ensuring that agency and department regulations of the executive branch are clear, necessary, legally valid, and available to the public. OAL is responsible for reviewing proposed regulations by California's more than 200 state agencies and departments that have some level or amount of rulemaking authority. The formal rulemaking process is established by California's Administrative Procedure Act, the APA. It's found in California's Government Code, and the APA sets forth the criteria by which OAL reviews all regulations. Now, every department, division, office, officer, bureau, board, or commission in the executive branch of California state government must follow the procedural rulemaking requirements contained in the APA, as well as a number of regulations that have been adopted by the Office of Administrative Law in Title I of the California Code of Regulations, unless that entity is expressly exempted by statute from some or all of the APA procedural requirements. Now, there are two types of rulemaking in this state. According to OAL, the two types of rulemaking procedures that an executive branch state agency can pursue are either regular or emergency. The regular rulemaking process requires that a state agency meet certain public hearing and notice requirements under the APA statutory provisions. The emergency rulemaking process has different requirements, but generally includes a brief public notice period, a brief public comment period, review by OAL, and an OAL determination. Whether engaged in the regular or the emergency rulemaking process, an agency or department of California's executive branch of state government is still bound to follow the procedural requirements set forth in the APA and Title I of the CCR. For example, this would include the contents of the rulemaking record, the specified timeframes, and the opportunities for public comment. The vast majority of regulations adopted pursuant to California's APA are submitted to OAL as regular rulemaking. Unless a proposed rulemaking action is submitted to OAL as an emergency rulemaking or is otherwise exempt from the APA, the regular rulemaking process must be complied with whenever an agency or department undertakes a rulemaking project. And the regular rulemaking process includes a number of comprehensive public notice and comment requirements. The regular rulemaking process also requires that documents and information on which the rulemaking action is based are made available for review and inspection by members of the public. Now, this comprehensive process is intended to further the goal of public participation in the rulemaking process and to create an adequate rulemaking record for review by OAL and, if necessary, by the courts in the state. In terms of emergency rulemaking, the general rule is that a state agency or department may adopt an emergency regulation in response to a situation that calls for an immediate action to avoid serious harm to the public health, safety, peace, or general welfare, or if a statute is deeming a situation to be an emergency under the state APA. Now, because emergency regulations are intended to avoid serious harm and require immediate action, the emergency rulemaking process is substantially abbreviated compared to the regular rulemaking process. OAL reviews emergency regulations for compliance with the APA's emergency rulemaking requirements, and proposed or adopted emergency regulations last for an initial period of 180 days, and upon application by the adopting agency, two additional 90-day periods of review, but that's the extent of it. Whereas a regular rulemaking results in a permanent regulation in the CCR. Now, if an emergency rulemaking is undertaken, what's called a Form 400 is used, and this contains the proposed text of the proposed regulation and the finding of emergency as submitted by the rulemaking entity. And these documents may be revised or withdrawn during the OAL's brief review process. Now, unless the emergency situation clearly poses an immediate serious harm, that delaying action to allow public comment would be inconsistent with the public interest, then OAL must allow 5 calendar days as a minimum for public comments after posting a notice of the filing of a proposed emergency regulation on the OAL website.